really warm welcome to all of you who are joining us here in person, but also to everybody who's joining online. We have a whole other contingent of people from various corners of the globe with us on this live stream as well. So welcome to the rights of nature and the crime of ecocide, this conversation that we're bringing to you today. This is really, this series of lectures, this is the first in a series of lectures, collaboratively organised between the Faculty of Arts and Humanities at King's College London and Arizona State University. And we've put together this sort of 5-year package of stuff to celebrate environmental humanities, to celebrate the work of our colleagues across King's, across ASU and beyond. And as I say, this is the inaugural lecture, but we'll follow up with another lecture next year in ASU, and the third partner in what we call the Plus Alliance is University of New South Wales in Australia, and they will probably be coming in to host one of the lectures further down the line. Just before I tell you, before we introduce this particular piece, I'll tell you, if I may, a little bit more about this complete package of work on environmental humanities that we're starting to do in this collaboration, through this collaboration. As well as this annual lecture, we have a series of research summits, the first of which is actually tomorrow, organised by my brilliant colleague, Rowan Boyson, whose work on air is an exceptional contribution to our understanding of the environment, of climate, and a crucial piece of environmental humanities scholarship. So we've got this first research summit tomorrow on air. You might guess that the next summit, which we're holding in Phoenix, in Arizona, is going to be on Earth, suitably, given it's in the desert. The year after that, we are hopefully going to be in University of New South Wales in Sydney with the theme of fire. And then the penultimate one the year after that is going to be hopefully in Bermuda, where ASU have a bit of a connection on water. And then the 5th year, we're going to have a big celebration, a big festival called The Fifth Element. And if you're intrigued by that, stay in touch and you'll hear more about this. We don't quite know what that's going to be yet, but it's going to be brilliant. And yes, there might be fancy dress around the Fifth Element theme. So that's where this fits, what this fits into. And this is the start of something we hope that's going to be quite big, quite exciting. And I couldn't ask for a better co-conspirator in this than Jonathan Bate. We've been talking about this for a year now and delighted to see this come to fruition. So I'm going to introduce Jonathan, and then Jonathan's going to introduce Philippe, and then we'll get going on the conversation. So Jonathan Bate is Foundation Professor of Environmental Humanities at Arizona State University. He's also a Fellow of the British Academy, and he's also a Senior Research Fellow in English Literature at Oxford University, where he was formerly Provost of Worcester College. He's also, last but not least, a Visiting Fellow at King's College London, which we're delighted to have this connection, this formal connection with Jonathan, as well as through the Plus Alliance. And Jonathan's the author of 20 books, several of which have won major awards and prizes. And he's known to many of you, I know, as an expert on Shakespeare and the Romantic movement, but most notably for our purposes today is The Song of the Earth, his 2000 publication, a really pioneering study in literary environmentalism. And he's also written several award-winning biographies of poets and the natural world: Wordsworth, John Clare, Ted Hughes. Jonathan was knighted by the Queen for his services to literary scholarship, and his most recent book is called Mad About Shakespeare and is a memoir, and I can thoroughly recommend that as a great read as well. So just before I pass over to Jonathan to introduce Philippe, I'm going to do a few thanks. We have some people to be extremely indebted to for today. We've been very generously supported by the Aurora Trust and the Tedworth Charitable Trust. Very enthusiastic and committed sponsors for this type of work, and we're hugely grateful to them. We're also really grateful to many folks locally who've just done all of the logistics to make this happen. Catherine Tidow and the research team in the Arts and Humanities faculty at King's, Paul Redman, Professor Paul Redman, who's our champion of environmental humanities in the Faculty of Arts and Humanities and who's been doing a lot of the work to get this together today. And of course, Rowan Boyson, Dr. Rowan Boyson, for the summit that we're going to be engaged with tomorrow. So let me pass over now, Jonathan, to you, and you can introduce our other esteemed guest of today, and then we'll get going.
Thank you very much. Good. Well, thank you very much for coming, and welcome to everybody around the world on the live stream. And again, special thanks to the Aurora and Tedworth Trusts. So yes, I'm going to introduce Philippe, and then the pattern is going to be, I'm going to talk for about 10, maybe 15 minutes about the history of the idea of the rights of nature. Then Philippe's going to talk for about the same length of time about the crime of ecocide and his work on that. Then we will be in conversation, and then we'll be opening it up to the in-house audience. I could spend the whole hour praising Philippe for his extraordinary achievements. I suppose the first thing to say is that when we started the publicity for this, he was a Queen's Counsel, but he's now, of course, the King's Counsel, so apologies for that correction. He's the Professor of Laws at University College London, where he's also Director of the Centre on International Courts and Tribunals. And there's no one better to be directing such a centre because he has appeared as a counsel and an advocate before just about every international court there is, the International Court of Justice, the International Tribunal on the Law of the Sea, which I think is quite relevant to some of our thinking today, the European Court of Justice, the European Court of Human Rights, the International Criminal Court. He's also a very distinguished writer. He's president of English Pen, the Organisation for Writers and Freedom of Speech. He's written, I think, about 17 academic books on the law, including Principles of International Environmental Law, which was one of his early books, but shows that this particular interest is by no means new to his work. Although, of course, what he's best known for is his work around genocide and crimes against humanity. In the last 5 or 6 years, he's moved away from writing strictly academic legal textbooks to produce a series of extraordinary books that combine wonderful storytelling with fascinating history and important points of law. It began with his book East-West Street, which won the Baillie Gifford Prize, the UK's leading non-fiction prize, and was highly praised around the world. I think it's been translated into about 20 languages, which sort of began from this extraordinary discovery of his own family roots in Lviv, in Ukraine, a place much on our mind, and where he was last week. But the discovery that the 2 Jewish lawyers, one of whom invented the idea of genocide, and the other of whom invented the idea of crimes against humanity, were also brought up in that same community. He followed that up with The Rat Line, about the extraordinary story of the Nazi Otto Wächter and his escape after the war. And then most recently, another highly acclaimed book, The Last Colony, about the very disturbing story of the Chagos Islands, where the British forcibly ejected the entire population so that the Americans could establish an air base. And like the previous books, this again uses narrative. It takes one particular character at the center of the story. It should also be added that Philippe is on the board of various theatres and indeed has been involved with a number of stage shows based on his work, also with an extraordinary documentary film, My Nazi Legacy, where he met with the sons of prominent Nazis, including Otto Wächter's son. And that makes it particularly appropriate that he's with us tonight for this event, because what's behind the idea of the environmental humanities is the idea that in order to address the crises of climate, pollution, biodiversity loss, we need not only the data, the evidence that scientists can give us, we need not only policy, political will, activism, and legal frameworks, but we also need a change in consciousness, a willingness for people to think differently, perhaps to think the unthinkable, and to think empathetically, imaginatively about our relationship to the planet, to the natural world. And it's the humanities, with our narratives out of history, the creative arts, philosophy, that provide those new ways of thinking. So we'll hear from Philippe very, very shortly. I can't wait for that. But to begin with, a short survey of the idea of the rights of nature. If we think about rights, we would immediately sort of think back to the development of notions of rights in the Enlightenment. The 1776 Virginia Declaration of Rights, which gave the US Constitution the idea of the inalienable right to liberty, life, the pursuit of happiness. Then, at the time of the French Revolution, the French Declaration of the Rights of Man and of the Citizen. And then in Britain, Thomas Paine's defense of the French Revolution in his book, The Rights of Man. And then, of course, the following year, Mary Wollstonecraft publishing The Vindication of the Rights of Woman. And then in 1807, the abolition of the slave trade, the beginnings of an extension of rights to formerly enslaved people. So there's a widening circle of rights. But what is striking about those early declarations, quite apart from the fact that they speak of the rights of men until Wollstonecraft come along, is that those early notions of rights are very much bound up with property. The language of the Virginia Declaration of Rights speaks of the right to enjoy property. And this, of course, goes back to the English Bill of Rights of 1689, which is based on the political theory of John Locke, where, again, you get the idea of the right to life, the right to liberty, but also the right to property. So initially, rights are thought of very much in terms of property. And that seems to me to create something of a problem for when we start thinking about the rights of nature, as we'll come to see. So the idea of an extended circle of rights is emerging there in the late 18th century. Now, it was the case that among the radical activists of the 1790s, you did begin to get a few people talking about the idea of extending rights beyond the human. John Oswald, very interesting, an English Jacobin, an English radical. I know about him because William Wordsworth met with him in revolutionary Paris. He wrote a book called The Cry of Nature, or An Appeal to Mercy and to Justice on behalf of the persecuted animals. He argues for vegetarianism there, not least under the influence of Eastern thinking, if one thinks about the idea of the sacredness of the cow in Hindu thought. And he's really also picking up on a very famous passage by the great jurist Jeremy Bentham, one of Philippe's predecessors at UCL. And Bentham, in his introduction to the principles of morals and legislation, talks about this idea of extension of rights. Other animals, which on account of their interests having been neglected by the insensibility of the ancient jurists, stand degraded into the class of things. The day has been, I grieve to say in many places not yet past, in which the greater part of the species, under the denomination of slaves, have been treated upon the same footing as animals are still. The day may come when the rest of the animal creation may acquire those rights which never could have been withheld from them but by the hand of tyranny. Then he mentions early French ideas of giving rights to those to be enslaved. And then he says, it may come one day to be recognized that the number of legs, the velocity of the skin, or the termination of the os sacrum are reasons equally insufficient for abandoning a sensitive being to the same fate. What else is it that should trace the insuperable line? Is it the faculty of reason, the faculty for discourse? The question is not, can they reason, nor can they talk, but can they suffer? Why should the law refuse its protection to any sensitive being? The time will come when humanity will extend its mantle over everything which breathes. We now know from recent research that it could be argued that trees can breathe and indeed be sensitive. Initially, though, that extension of rights was very much focused on quadrupeds with the Cruelty to Animals Act. So there's a 50-year lag there between Bentham's idea, Oswald's thinking, and the passing of an act. And it is often the case that there is this time lag between the development of an idea and the formation of a law. So This idea of the extended circle of rights, first property owners, then all men, then women, then enslaved people, then animals that suffer. Could that circle be extended to all species, or indeed to all of nature? Another fascinating English radical of the 1790s was a man known as Walking Stewart. He was called that because he walked all the way from Madras to London via Russia and most of North Africa. He walked, he didn't take a horse because he thought that was cruel. And he argues in an extraordinary book called The Apocalypse of Nature that all of nature is animated. So he says at the beginning of that book that 19/20ths of animated matter has been sacrificed to the protection of our species alone. But a time will come when law should be extended to all of nature. And he writes about our violence upon nature, about the cruel institutions of society tyrannizing over nature. He suggests that we are ignorant of the chain of connection between self and nature. An idea that a lot of the Romantic poets pick up on, that self and nature are interconnected. He actually says that rivers, vegetables, animals, all of nature have personal identity, and that universal sympathy should extend beyond the contracted points of parental, social, patriotic, human affection and love to the great circle of sensitive nature. So again, that idea of an extended circle of rights. Possibly the earliest constitutional document to give some kind of rights to nature was the 1838 Constitution of Pitcairn Island, where built into the Constitution were restrictions on deforestation and the killing of the white bird. As far as I can work out, the white bird is the white tern, which was a species that never flew further than 30 miles from the coast, and so was a very valuable navigational tool. If you were out in your boat in the Pacific and you got lost, follow the white tern and you'll get back to the coast. But notice there that the forest and the bird are being given rights, not out of principle, but out of pragmatism. The forest the wood to prevent deforestation, sustainability we would now call it, and the bird, navigational assistance. So there nature has some rights, or parts of nature have some rights, but as a resource, not in any inherent sense. If we go further in the 19th century, we find the great French writer Jules Michelet co-writing, although uncredited with his wife, in his book called The Sea. He speaks about the attack of the conquest of the sea by humankind. And he sees colonial expansion as the cause of that. And he speaks about whaling and the great species of whales on the verge of extinction. At the climax of that book, he argues for what he calls the rights of the sea. The great nations of the world must come together to replace this savage state of things with a state of civilization in which man is more thoughtful and does not squander his wealth while at the same time hurting himself. France, England, and the United States must propose a declaration of the rights of the sea and convince the other nations of the world to promulgate it together. Well, about 100 years later, something of that sort did emerge, although once again the treaty language remains that of resources, not rights. The United Nations Convention on Fishing and the Conservation of Living Resources of the High Seas was passed in 1966, although still 20 nations have not ratified it. Jumping into the 20th century, in a way the key text, and I think Philippe may be talking about this as well, for thinking about extending rights to the non-human, was an article by the legal theorist Christopher Stone called "Should Trees Have Standing? Toward Legal Rights for Natural Objects." And he begins it by talking about the unthinkable. And this is where I think the kind of humanities idea, let's think the unthinkable, let's imagine a different way of seeing, a different form of consciousness. In The Descent of Man, Darwin observes the history of man's moral development has been a continual extension in the objects of his social instincts and sympathies. Originally, each man had regard only for himself and those of a narrow circle about him. Later, he came to regard more and more not only the welfare, but the happiness of all his fellow men. Then his sympathies became more tender and widely diffused, extending to men of all races, to the imbecile, maimed, and other useless members of society, and finally to the lower animals. The suggestion that that circle of rights could be extended. Stone says, well, people who say a tree or a river cannot have legal standing, well, surely they can't have legal standing because they are not persons. They cannot speak for themselves in court. But Stone points out that children, corporations, nations, ships have legal standing, but cannot speak for themselves. They need representation. So why could a tree or a river not have legal representation on its behalf? And that is indeed exactly what happened in a famous case of that same year, 1972, which went to the Supreme Court, in which the Sierra Club argued as representative on behalf of a piece of land in a case against Morton, who was the Secretary of the Interior. The Supreme Court threw out the case, but Justice Douglas dissented, and in the course of his dissent says the river as plaintiff speaks for the ecological unit of life that is part of it. The voice of the inanimate object, therefore, should not be stilled. And Justice Douglas went on to say a time may come when a tree or a river might have standing. And perhaps that time is now coming. In 2008, the rights of nature, Pachamama as it was known, were enshrined in Ecuador by its constitutional court. And Ecuador led the way. Other nations have now followed. And then in 2017, New Zealand granted personhood to the Whanganui River. Extraordinary developments that would have been unthinkable a generation ago. So I end with a question. 130 years after my friend Walking Stewart proposed that rights should extend to all of animated nature, are we moving towards a legal underpinning for his vision, which is this: man in this state, sensible of his relation to all nature, must in all social organization comprehend all the inhabitants of the globe upon which he exists, and so subdivide and connect this universal association as to give it one spring and one object, viz. The well-being of all animated nature. So now Philippe is going to tell us how that can happen through ecocide becoming a crime. Thank you.
Wonderful. Do you want to give me that? Yeah.
Just a quick moment.
Yeah, great. Gosh, that is so wonderful to listen to. I should say, since Jonathan hasn't said it, is our starting points, in a sense, are very different. Jonathan has started in the world of literature and literary theory. I've come to these issues from the world of law. But actually, we overlapped in our very early days as research fellows at St. Catherine's College, Cambridge. And I do find it fascinating the way these things happen, and that we find ourselves now here 40 years later, where our worlds have connected and overlapped, and we're reading the same things, but coming to them from different perspectives. Life is sort of like that in interesting ways. So I'm going to take on the story of where, in a sense, we go from here and put it in quite a sort of personal framework. I studied law starting in the late 1970s and into the early 80s. And at no point in 4 years of undergraduate and graduate legal studies did anyone ever talk about the protection of the environment under the law. It was just a non-issue. It was a generational change that came much later and is increasing now. I had no legal training on the environment. I had no apparent interest in the environment beyond I love walking and Hampstead Heath and going to hills around the United Kingdom and other places. And then in 1986, in April, there was an accident at a large nuclear facility in then the Ukrainian Soviet Socialist Republic, today the Ukraine, but under the Soviet guise, which spewed out vast quantities of radionuclides, radioactivity, across much of Europe and beyond. And we were together then at St. Catherine as research fellows, and out of the blue, I got an invitation to give a lecture in Washington, D.C. at the Walter Annenberg Foundation on how the law, international law, might address these kinds of issues. And I remember getting the invitation and realizing that I knew absolutely nothing about the subject. But it was interesting, and I would sort of do a sort of deep dive and see what there was. And basically, there was nothing. There was no international law, really, at that point, amazingly, as recently as 1986, on the protection of the environment. There were a few odd treaties and conventions from the 1920s and 30s on the protection of particular species. There were conventions on whaling, but it was about killing whales, not conserving whales. And there was nothing in the United Nations Charter, adopted in 1945, and there was this obscure text that had been adopted at a UN conference in Stockholm in 1972, the Stockholm Declaration, but we were told that wasn't legally binding. It was just an aspirational statement with its famous Principle 21 on transboundary pollution. It didn't create legal obligations. There'd been a couple of cases, the famous Trail Smelter case of 1941, the nuclear test cases of 1973 between New Zealand and Australia on the one hand, France on the other. But when you read them, they really weren't about the protection of the environment at all. They were about the protection of territory and property. Very much the analysis that Jonathan has described. So I got increasingly sort of fascinated. I wrote my paper, which became actually my first book in 1988 on Chernobyl, international law and communication, and the sort of embryo of an interest in how international law could address environmental issues. That then caused me to receive an invitation from an environmental group in the United States, the Sierra Club Legal Defense Fund, a couple of remarkable characters, Wendy Dinner and Zerwood Delkey, who had read the paper and said, could we join forces, US domestic environmental law, which, as you pointed out in relation to the Sierra Club case, had begun to be quite significant. President Nixon had created the Environmental Protection Agency in 1972, and that had created domestic law. And the Sierra Club Legal Defense Fund, Skulldugg, was interested in internationalizing the whole thing. And so we began. We created, at King's, a Center for International Environmental Law, which was the first of its kind to provide legal assistance, in particular to the Global South, developing countries as they were then called. And the first big project that we worked on in 1988-89 was climate change, before it was an issue. I went to the very first meeting ever on the idea of a legal convention on climate change, addressed remarkably by Margaret Thatcher, the Second World Climate Conference in Geneva. And she was, I've got to say, I'm not a Thatcherite, but she was terrific. She was a scientist. She understood already in 1990 what was happening. And so one thing led to another, and over the next 10 years, I got extremely involved. I have to tell you that of all the texts I have ever read as a law student or a legal academic, the one that has influenced me the most and the one that is most beautifully written is this one. Jonathan and I didn't coordinate. And this text, which was given to me by Derwood Zelke in 1987, which of course I'd never heard of, by Christopher Stone, is, I think, the heart of what followed subsequently. I reached out to Christopher Stone with Derwood. We became very close. He wrote a second book. This was just a law review essay published in 72, but he then wrote a book published by Princeton University Press called The Gnat is Older Than Man. And the central thesis, which I think is the beating heart of what we're talking about, is that we need to rejig our relationship to the law. The law, Stone's thesis was, and would have been for the rest of his life, he passed away last year, is essentially anthropocentric. It is directed entirely to protecting the well-being of the human, the individual, or the group, or the individuals and groups within a country, and so on and so forth. And his fundamental idea was that that is damaging, that it is a fundamental contradiction, and ultimately you cannot protect the environment by adopting an anthropocentric approach. You have to rethink law's relationship to nature. That is the Christopher Stone thesis. And it is not only a powerful thesis, but this guy can write. His dad was a wonderful writer and philosopher called I.F. Stone, who for many years was a sort of pamphleteer in the United States, who wrote the most incredible things. And so this combination of someone with a brain who can actually write in a way that's accessible is a winning combination. So these ideas really influenced me a lot, and many people a lot. And over the next 15 years, we got increasingly involved in litigating cases, starting off doing work for Greenpeace, for Friends of the Earth. One of my first briefs as a barrister was to be hired by Greenpeace International to be their legal advisor in the negotiations after the Chernobyl accident. And it was a sort of classical path followed by the sort of direct action type of environmental communities. Find some establishment figure, preferably a white male at a well-known university who you can attach to your team, and that will get you into the door. And once the door is open, all sorts of mischief can follow. And of course, the Greenpeace folks would do all sorts of things that I would have been trained to be completely horrified about at the International Atomic Energy Agency, and we were constantly being told off by the Director General and his legal advisor, who happened to be Hans Blix and Mohammed El-Baradei, who, in the context of the Iraq War, would become extremely famous and well-known as the weapons inspectors. But this is a classical path for the students here. Be part of the establishment by all means, but attach yourself to more far-reaching progressive and radical elements and allow yourself to be used to give them access to places they wouldn't give access to. I'm a passionate believer that you need a broad church in order to really effect change, and it's a combination of the practical and the intellectual and the scholarly and the legal. You're getting the sense of what I'm saying. The upshot was, in 1996, a very significant change occurred in an obscure advisory opinion given by the International Court of Justice. I had, as a young academic, by then I was in my mid-30s, fights with one of the great public international lawyers of the United Kingdom. If any of you are international lawyers here, you'll know the name Ian Brownlee. And Ian Brownlee had written the most famous textbook on international law, Brownlee's Principles of Public International Law, and it had not a word about the environment. And we'd exchange these letters, and I'd say, come on, Ian, it's time to open up. And he said, no, I'll only open up when the International Court of Justice rules that international law imposes obligations on states to protect the environment. And that happened in 96. And that was the catalytic moment of change. And thereafter, there were a series of cases before international courts and tribunals in which, for the first time, the protection of the environment, not as an end to protect the human, but as an end in itself, became inscribed in the international legal order. I mean, on the outer margins, not yet absolutely central, but that change began to happen. And it began to happen across the board in the field of international law. One aspect that I've always been particularly interested in is in the field of human rights. None of the human rights treaties and conventions, apart from the African Convention on Human and People's Rights of 1968, has the protection of the environment written into it. The European Convention on Human Rights doesn't deal with environmental protection. But the judges, over time, reinterpreted the convention to provide for a degree of environmental protection. The famous first case, Lopez Ostra versus Spain, concerned pollution from leather tanneries. And in that judgment, the court for the first time said the human is and should be protected from environmental harm. There is here, of course, a fundamental contradiction, because you're wrapping environmental protection around the well-being of the human. You're essentially taking an anthropocentric approach. So the environment is effectively harnessed to protect the well-being of the human, coming back to these earlier extraordinary 18th century writings, which are bang on point. I mean, way ahead of their years, absolutely, completely consonant with the kinds of things that fell into my inbox intellectually and in courts and tribunals around the world. But the environment went up the agenda. And interestingly, just a slight tangent, Jonathan mentioned my most recent book, which is about the Chagos Archipelago, a group of islands in the Indian Ocean, and the forcible removal of the entire population, descendants of enslaved people, all black, and outrageous, in my view, a crime against humanity. And they want to go back, and they will, I think, soon be able to go back. One of the islands is famous or infamous, Diego Garcia. It is a major US military base given to the Americans by the British for 70 years, from which the bombing of Baghdad began, and it was a black site for extraordinary rendition, torture, and various other activities in the post-9/11 attacks. And the British got into terrible trouble about it, David Miliband in particular, because it became apparent that the British were blissfully unaware of what Diego Garcia was being used for, and had given misleading answers in Parliament to questions. And so someone in about 2008, 2009 came up with a fantastic wheeze that what we will do is create the largest marine protected area in the world. And we will protect, the United Kingdom, the entire 640,000 square kilometers of the Chagos Archipelago, except for the military base right in the middle, which could continue to get up to whatever it wanted to get up to, unregulated by these environmental constraints. And the great idea put forward by Mr. Miliband was, of course, the marine protected area would stop all human activity in the area and absolutely protect the environment. Now, unfortunately for Mr. Miliband, at this very moment, WikiLeaks spewed forth millions of secret US diplomatic cables, some of which dealt with Chagos. And in one of them, most unfortunately for the British and the Americans, was an exchange from the US Embassy in London to the State Department in Washington, summarizing a conversation with the head of the British Indian Ocean Territory, the illegal British construction around Chagos, saying that one of the great things about the marine protected area around the Chagos Archipelago, 640,000 square kilometers of pristine environmental area, is that by banning all human activity, it will be impossible for the, and I'm sorry to use these words, but that's what the WikiLeaks document says, that the manned Fridays would not be able to go back. So the environment was being harnessed, if you like, as a neo-colonial exercise to stop people from returning to the homes they wished to return to and had been forcibly deported from. So this interplay between environment as a real end in itself and environment being utilized for other means is absolutely the beating heart of international law. Very briefly, coming up to ecocide. We, in 2019, the cast of characters here were approached by an NGO whose representative and director is here today, Jojo Mehta, to take forward an idea that reflects the background of all of these developments in international law and wants to take it a step further. The context was that international criminal law, which had developed since 1945, starting with the Nuremberg trial, had 4 international crimes. You've all now heard of them and you hear about them every day, unfortunately. War crimes, crimes against humanity, which is about the protection of individuals, genocide, which is about the protection of groups, and the crime of aggression, which is about the criminalization of manifestly illegal war, Iraq, Ukraine. But all are, for perfectly understandable and reasonable reasons, highly anthropocentric. They are intended, totally well-intentionally, to protect the human. The gap in all of this international criminal law is the protection of the environment. In the late 1960s, in the context of US use of napalm, Agent Orange in Vietnam, an American scientist first used the term ecocide, that it was time to criminalize the use of the environment as a weapon of war. And that was taken forward amazingly at the opening of the Stockholm Conference in 1972 by Olof Palme, Prime Minister of Sweden, who invokes and says one day there will be a crime of ecocide. Don't have time to go through the whole thing. But coming into more recent periods, a remarkable English barrister who is sadly no longer with us, Polly Higgins, really ran with this idea and created really a global network of individuals committed to pushing the idea that international criminal law, rather like Christopher Stone's thinking, had to be reconceived, not only about protecting the human, but genuinely protecting the environment. And so that made considerable progress, but coming back again to the little anecdote about having to be wheeled in by Greenpeace at the International Atomic Energy Agency, the folks from Stop Ecocide, I think, probably decided they needed some more establishment kind of characters to open doors that remained firmly closed and construct a working group to come up with a viable definition of ecocide that could be used going forward. And over a period of about a year, this group here, which is, I think, as balanced a group as you could possibly imagine in terms of national backgrounds, ethnicity, race, color, gender, orientation, everything, came together and produced a consensus document in the summer of 2021. And the central definition of ecocide that we came up with invited to prepare a draft text which could be integrated into the statute of the International Criminal Court was that ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. But the central thrust of the definition was that it had to be ecocentric. You did not have to prove damage to humans in order to form a cause of action. And I think what we really wanted was to effect a change of consciousness. I was deeply inspired by the individuals in 1945, Jonathan mentioned them, Lauterpacht and Lemkin, who essentially invented the concepts of crimes against humanity. People think these concepts exist since time immemorial. They don't. If you look at my book, East-West Street, you'll see they were invented in the summer of 1944 to deal with a particular moment. And a lot of people said, oh, this is hopeless, ridiculous. Why do we need these new wacko ideas? But it happened. And I think we're now seeing, in the context of the development of international criminal law today, and it will be for the next generations to run with it, the idea, the real idea, that the protection of the environment must be an end in itself, and a human being who engages in this kind of unlawful or wanton act with the requisite mental intent would be committing a crime under international law, actionable anywhere in the world. Couple of points to make. We did not provide a list of examples. We had a tremendous debate about that, and the group, frankly, was deeply divided, with very respectful reasons on both sides. I was part of the group, in the end the majority, who did not want to put a list of acts. Why? You cannot, in 2021, include a list of acts and not mention climate change. But the moment you put climate change into a text like this, the project is dead. Because for 30 years, countries have been trying to negotiate conventions on climate change, and various forces immediately cut in and stop it. So it ought to be like genocide and crimes against humanity. Leave it to the judges, leave it to the prosecutors over the next 20 and 30 years to work out what it means in practice. and just avoid the difficulty of giving individual examples. I have my views about what might be individual examples, but I'm very restrained in talking about it because the moment you start talking about individual examples, you've got opponents for the idea. So my sense, and in the end it was a consensual view, is no definition. But we can maybe come back to these kinds of issues. The response was beyond what I think anyone else, Jojo I think would agree, would have imagined. This, I don't know how this happened, but within days the Secretary General of the United Nations was declaring this was a terrific definition, absolutely we had to run with this. And governments began to run with it. And the first government to have adopted a policy of wishing to incorporate this definition into its domestic law and into its international practice was the government of Belgium. And you're beginning to see now movement to the point that I would say the question is not whether there will be an amendment of the Statute of the International Criminal Court to include a concept of ecocide, but when. I don't know whether it's 5 years, 30 years, 50 years, but you can feel the sense of movement happening. It's slightly been, I think, suspended by what's going on in Ukraine because that's sucked up a lot of the energy for obvious and understandable reasons. But there's no doubt that it excites so many people in so many different places. And I was very pleased a couple of weeks ago when David Lammy, the Foreign Affairs spokesman of the Labour Party, declared that ecocide would be part of the Labour commitment going forward. That's very significant. And that is supported also by the leader of the Labour Party. I think Jojo was extremely surprised about 3 weeks ago. I should say I've litigated a lot of international criminal cases over the last 30 years. I've seen a lot of absolutely horrendous things. One of the people I've worked with very closely, we've done genocide and crimes against humanity cases together, is Keir Starmer. And he came over for tea about 3 weeks ago. And at the end of it, I was late for a web thing with Jojo. And I just said to him, do you want to talk to a few people who want to hear about ecocide? And I was surprised, actually. He said yes. And so I signed on to Zoom and said to Jojo, I'm really sorry that so late for this, but I've just been with someone, but I think he'd like to speak to you and speak to a few people. And Jojo met his face when she saw Keir Starmer turn up and actually say, yes, I do want to engage in this. I mention this simply to indicate that the issue is reaching parts now. There is a change of consciousness taking place. It's not wacko, it's not ridiculous. There is something happening. We had a private conversation also with the then Environment Minister, who said personally he was extremely supportive from the other political party. So something is happening. And I'll stop there and let's go to a conversation.
Fantastic. Well, we'll talk for a little bit and then we'll go to the audience. I wanted to begin actually with this question of property, because that is a fundamental problem, isn't it? Given that, as I was suggesting, so much of the history of rights are bound up with property rights. In a way, that the premise of a non-anthropocentric approach is to say that the earth, or indeed the sea, does not belong to an individual, a corporation, a nation. In a sense, it belongs to itself, that the rights of nature trump property rights. But presumably, sort of negotiating that, those kind of conflicting rights is going to be a problem for this going forward.
Well, I mean, you've told a story which goes back at least 3 centuries, and shifting a community or many communities is not an easy thing to do. It really takes time. It happens incrementally. Occasionally there are revolutions. There was a revolution in 1945, and the revolution in 1945, which I think people were blissfully unaware of, was to say for the first time in human history, the rights of the sovereign are not absolute. There are these things called individual rights, today we call them human rights, and group rights, the obligations of genocide. And those moments of fundamental change, of course, take time to really establish themselves in consciousness, and you find resistance still today to these ideas. You know, governments complaining about judgments of the European Court of Human Rights and somehow limiting the power of the sovereign to do whatever it wants in a particular moment. So I think we've got an analogous situation in which, for me, it's not so much about the power of property rights, because the environment is very largely not owned and not susceptible to ownership in a classical sense. It's, you know, the atmosphere, the climate system, the ozone layer. No one owns these, but we're all dependent upon them equally. And the issue is, I think, rather to nudge the legal order into saying that the well-being of the natural world is a valuable thing that should be subject to legal protections, irrespective of the need to prove either that a person or a corporation has a property interest in that resource, or that harm will happen at all to humans. I mean, in our discussions about ecocide, this focus, for example, imagine there is some extraordinarily wonderful species in which there are 4 members of that species left in some tiny place in the world, and someone wants to kill off those last 4 members of that species. Well, you know, if you kill off those last 4 members of that species, no human actually is going to suffer physical harm. There may be loss of immunity, the knowledge that these species exist, which contributes to our sense of well-being as humans, you could say is affected, but you don't have to prove that. It's that there are certain natural objects, the protection of which we consider to be so indispensable that the law should be harnessed to protect them. That's the fundamental change.
I was just thinking about property again for a moment. It was Rousseau in his discourse on the origin of inequality said that the origin of inequality came at the first moment that a man enclosed a piece of land and said, "This is mine." And there is a sense, isn't there, in which the rights of nature are perhaps closely bound to the rights of the dispossessed or the marginalized. I'm sort of thinking of the way that, if you think of some of the great environmental disasters, Bhopal in India, Love Canal in America, it's always the marginalized community, typically communities of color, or if one thinks about the Amazon rainforest. So there is a sense in which environmental protection or the rights of nature actually go hand in hand with a sense of the rights of the poor and of the excluded. But in a way, I suppose, in your work, you didn't want to make that connection, because in a way that sort of goes back to a kind of anthropomorphism.
We did make that connection. I'll say a bit more about that in a moment. And it's the reason that I mentioned the case of Chagos and the marine protected area, celebrated, I'm sorry to say, by all the major United Kingdom NGOs. The Zoological Society of London, WWF, Greenpeace, Friends of the Earth, all applauded David Miliband's announcement that he was going to create a marine protected area. And I literally had to get on the phone and say to people, do you realize what's going on here? You are being used to prevent Chagosians from returning to the homes from which they were forcibly removed 50 years ago and to which they want to go back. And very slowly, all the environmental NGOs began to peel off, and they just hadn't thought about it. So this issue is absolutely there. The way in which the inequalities around the world mean that if you adopt a single environmental rule applicable across the world, you essentially allow the industrialized North to maintain the status quo, and the globalized South is unable to follow a path of development which would raise educational standards, raise health standards, or whatever. And this is an absolutely fundamental problem in the case of climate change. Because if you say everyone has the same obligations to reduce CO2 emissions without taking into account historical emissions, you're effectively maintaining the status quo and inequality. So that cannot happen, and that's why regulating climate change has been so difficult. But there's another area where this is coming up right now. And it's really complex, which makes it interesting. You mentioned an old convention on the law of the sea, and in fact, that convention has fallen by the wayside, so it doesn't matter too much that it never came into force. It was replaced by a new convention in 1982 called the United Nations Convention on the Law of the Sea. And that convention, as originally adopted, characterized the resources of the deep seabed in the high seas as common heritage of mankind. Okay? And that was adopted in 82, and it happened to coincide with the arrival in power of Ronald Reagan and Margaret Thatcher, who wanted to commodify the resources that had just been given to the world. And so there were a series of re-amendments which came into force many years later. And the technology has only come into being now, in these last 4 or 5 years, to be able to engage in what's called deep seabed mining. And there is a huge battle going on now as to who has the right to access those resources of the deep seabed and under what conditions. And the country that's leading the fight to get the resources out from the seabed are very often the small island developing countries like Nauru, for example, with opposition from the industrialized North that wants to protect the marine environment of the ocean. So you can see straight away, the equities here are really complicated. You have sympathy for the desire to protect the well-being of the oceans and not create some sort of massive exploitation. On the other hand, small global south countries that have no resources of their own want to get their hands on these resources in order to be able to develop economically. And this raises now sort of fundamental ethical questions that goes right down to my level. As a barrister, you get contacted by a country that wants help to litigate one of these cases. What do you do? It's the same with oil and gas. Some of the poorest countries in the world, I'm thinking of Guyana, have identified oil and gas off their coasts. They see these resources, understandably, as a quicker means to economic development, but they've come into the context of climate change. So the issue of inequality is at the heart of the question. And we addressed this issue, and it was really complex. With our definition, and I'll just explain here because it's absolutely the heart of what we did. Ecocide means unlawful or wanton acts. There's a double threshold there. Unlawful under national law or international law, but international law makes unlawful very little. And if a state wants to get by the unlawful under domestic, all it has to do is change its law and say we can cut down all the trees of the Amazon, it's lawful, and so there's no problem. We can do it without threat of being indicted for ecocide. So we had to come up with another standard, and the standard that we came up with, and I'm the first to say it's far from perfect, we had very limited time, is a wanton act. So here's the definition that we came up with for a wanton act. Wanton means with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. And inherent in that definition, which this is all easily available on the web and we can circulate the definitions, is the following point. You could imagine a scenario in which the same act conducted in the United Kingdom would be ecocidal, but if conducted in Guyana, would not be. Okay? That's right now, for example, in relation to fracking, or in relation to, as the esteemed Mr. Rees-Mogg said, I want to get every single drop of oil and gas out of the North Sea. Okay, that's what he wants to do, but actually the UK has a whole raft of environmental obligations that other countries may not have. I think there's a decent argument that for the UK to proceed along that path would be ecocidal. And it was very interesting during COP26, as some of you know, when the former esteemed Prime Minister of this country announced in the middle of COP26 that the British government was going to authorise a new coal-fired power plant. So they very soon backed off that because, of course, everyone said ecocide, ecocide, ecocide. And the heart of the issue is exactly that. What do we do about the fact that some people are living in abject poverty around the world? And to open a coal-fired power plant or a gas field would provide hospitals, schools, and various other things. And yet you then have a world in which different standards apply to different people depending on where they happen to be. And that raises other fundamental concerns. That doesn't apply in relation to crimes against humanity and genocide. You intend to destroy a group in whole or in part, 10,000 people, whether you do it in Britain, United States, India, China, Myanmar, Kosovo, wherever, it's a crime against humanity or genocide. What do we do with the environment? I don't have simple answers to this, but it's out there as a very big issue.
Just turning from it, we'll go to the audience in a moment, just one more. You're talking about small countries there, and in your talk there was quite a lot of optimism about countries adopting this, but sort of small countries like Belgium.
Not a small country.
Well, I was going to say...
global colony.
Once upon a time.
Yeah.
The United States and China, between them, 60% of global emissions. Are you at all optimistic that the United States or China might sign up to ecocide?
No, I'm not optimistic at all. Quite the opposite of optimistic, whatever that may be, beyond even pessimistic, I would say. But here is the interesting thing. The International Criminal Court, those two countries are not parties to the Statute of the International Criminal Court. There's about 130 countries who are parties to the Statute of the International Criminal Court. But the ICC, in its wisdom, in the case of the Rohingya community from Myanmar who are being horribly abused, whether you call it a crime against humanity or a genocide, they are being abused and mistreated, and it is horrible, have migrated in very large numbers to Bangladesh, a place called Cox's Bazar. Bangladesh is a party to the ICC statute. Myanmar is not. So on the interpretation of the statute, you cannot exercise jurisdiction over anything that happens in Myanmar because they're not a party of the statute. But anything that happens in Bangladesh, the court can exercise jurisdiction. So the court has recently ruled, a panel of 3 judges, that the inability of the refugees from the Rohingya community stuck in Cox's Bazar in Bangladesh to return to their homes in Myanmar is arguably a crime against humanity, which falls within the jurisdiction of the court. So imagine a transboundary air pollution situation. Something happens in China, but the consequences are felt across some boundary in a country which is a party to the statute of the ICC. On that theory, the ICC would be able to exercise jurisdiction. The reality is we live in a world that is entirely artificial. The disconnect between the world of sovereign states who can decide whether or not to be bound by a particular treaty or to join the International Criminal Court is disconnected from the real ecological world in which we all share a single planet together and equally. And that is a problem with the nature of the international legal order, which will have to be addressed.
And of course, the planet, 70% of which is sea, and national waters are relatively bounded. International waters, that's a whole other area. But I think we should allow our audience...
But just to conclude, I mean, there's movement. That's the way. Just what I loved about your slides is what you saw is that these ideas that were articulated in the 18th century didn't disappear into nothingness. They have resonance today, and they've begun to effect very significant changes. That's the optimistic take on it.
Yeah, and it is, so there's a lag, maybe a long lag, but once the idea is seeded, it won't go away. Thank you. Right at the back, there's a roving mic right beside you.
Thank you very much. My name's Ewan McGahey from Law School at King's College London. Really enjoyed the talk and the definition. I wanted to ask you about the applicability to corporations, and whether, it might be a very short answer, but if we take ExxonMobil, they wrote an internal memo in, I think, 1977 saying that we know that massive oil operations that we conduct is causing global warming. And then in the 1980s, they set up a campaign to deny the effect. So, I mean, I'm glad that you mentioned the meaning of wanton. I mean, there is certainly an entity which knows that it's going to have huge economic benefits itself, namely profit, but goes ahead and does things that have very, very serious consequences, like climate damage. I call it climate damage, by the way, nowadays, instead of climate change, because climate change sounds sort of warm and fuzzy in some way. Change is sort of happy. But my question is, can there be, or do you envisage any applicability to corporations, or is it just states?
No, we did talk about that. As you will know, but maybe others don't know, the International Criminal Court only has jurisdiction over individual living human beings. And so there is no jurisdiction before the International Criminal Court over corporations. I happen to think that's not a problem at all, because corporations have chief executive officers, chief financial officers, shareholders, members of the board, and they are living human beings who are subject to the jurisdiction of the International Criminal Court if they have the nationality or they operate in a state which is a state party. So it's never bothered me too much. This came up in a lot of the media after we came up with our proposal, and one of the things that was interesting was that it sort of crossed a line in terms of media interest beyond the usual progressive suspects into Wall Street Journal, Financial Times. And I remember, in particular, a very interesting conversation in being interviewed by the journalist from the Financial Times, who was really pressing me to identify, because the same thing goes with countries. Countries can't be hauled before the International Criminal Court, but a president can, an environment minister can, and that's how you get them, basically. So the journalist really pushed me on which presidents, which chief executive officers, and as Jojo knows, I did not want to be quoted as saying X, Y, or Z, because the moment you do that, you've got an opponent. So she said, well, can I, in my article, make some suggestions? I said, yeah, that's for you. Just don't say it came from Sands. Just, you decided. Then when she published her piece, she selected Bolsonaro for Brazil for the rainforest stuff, and the chief executive officer of ExxonMobil, which I understood he was extremely unhappy about. And here there is a very interesting generational issue. I mentioned this before, people who've followed some of these webinars. I mean, I sort of think that the kinds of cases and things I get involved in over the last 20 years are sort of interesting, all of them. But I've never had the situation before where all three of our children who are in their 20s, same age as yours, when The Guardian ran a story saying Sands was going to be on this, working group, they all WhatsApped me and said, finally, Dad, you're doing something useful and important. And And it's really interesting, and that really motivates people from my generation who feel we've really let down people from the younger generation who is here. We've left you with a pretty shitty world. And I have to say, those kinds of communications from younger people, school kids, university students, really, really motivates people like me and all of us. We feel a big responsibility, and it is for that generation to push. And if that generation pushes, something will happen.
There's one at the front.
Hi, Philippe. My name is Shaurya, and I was from King's College London, the law school. I actually did my dissertation on ecocide. I have a specific question about the wanton element. Obviously, there is a cost-benefit analysis, which brings an anthropogenic element into this. Do you think this element could diminish the gravity of the crime as opposed to the other crimes in the ICC statute? There's another part to this question. Let's assume the definition is adopted. For pragmatism, it's a good definition that embodies both the principles of environmental law and criminal law, which it does, according to my perspective. It's a good balancing act. How would one go about conducting this cost-benefit analysis, especially when we know that the costs of environmental destruction aren't evenly distributed and usually prop up later? Do you think there should be like a guidance document maybe?
No, thank you very much for these questions are very interesting. I mean, you've understood and you've seen in reading it that we were struggling with exactly the things that you're thinking about. We had a limited period of time. We had 6 or 7 months. You know, we were all doing other things. Both of you in your questions touched on issues that were very, very significant for us. I tend to be quite a pragmatic person. The best is the enemy of the good. So I'm turning my mind to the question, how do we amend the statute of the International Criminal Court? The vast majority of countries who are parties to the statute of the International Criminal Court come from the global south. So when the drafts begin to emerge, the presidents of these countries are going to say to their legal advisors and their economists and their civil servants, well, what does this mean for us? What am I signing on to here? And we need to help the people who give the answers to say, don't worry, you'll be able to do most of the things you still want to do. It's just these really egregious things. And there is a real practical problem because it does diminish the scope of what is going to be the effect. But I'm a passionate believer in incrementalism. You know, when I was at St. Catherine's with you in the 80s, you might remember there was a wonderful man who's the professor of English legal history, John Baker, an extraordinary scholar. And you know, it was really a real thrill for a 24-year-old to be invited to lunch by John Baker, you know, at high table, and he'd say, "What are you working on, Philippe?" And I'd say with enthusiasm this or that, and he'd say, "Oh yes, we had a similar problem in English law in about 1472, and it took 283 years to sort it out." And that's where we are on international law. The idea that we're going to get quick fixes and we're going to sort it out. So you are constructing, you're trying to change the direction of the ship. You're engaged in an exercise in construction. It's not going to change things overnight. It's not going to stop climate change. But over time, it is going to stop certain things. You know, when the guys invented the notion of genocide in 1945, and it was incorporated into the statute of the International Criminal Court, could they have imagined that 70 years later there would be a case at the International Court of Justice in which the Gambia, a small African country, brought a case against Myanmar in relation to its mistreatment of the Rohingya to say, you can't treat those people in that particular way. I had a very moving encounter at an academic conference in Washington, D.C., at George Washington Law School, about a week before the oral arguments on the provisional measures phase of the Rohingya case. And one of my co-panelists is a remarkable man called Thomas Bergenthal, who had been the American judge at the International Court of Justice, but as an 11-year-old boy was in Auschwitz, and who was under the care of Dr. Joseph Mengele, and who unbelievably survived. And he said to me, I've been following your case, Philippe, on the Rohingya. It's incredible. He said, could you imagine in 1942, when I was at Auschwitz, if there had been something called the Genocide Convention, and if some faraway African country had decided to sue Germany to say you can't do that. So it's small steps, you know. I'm not starry-eyed about international law. It's one step at a time. And slowly you begin to construct, and we have to hope that it's going to be in time to stop us from catastrophe. I don't know whether it is. But that's the realist approach to how you do this. And I think that's my answer to your question. Wanton was what we were able to come up to. The world of international law is a deeply conservative world, and states who are needed to adopt, as you know, any changes, generally don't do something that's never been done before. I mean, 1945 was a real exceptional moment. And so in drafting our definition, we're really careful to take text from other bits of international criminal law that already existed, so that we could say to all people, no, this is not new. This exists in Article 37 of that. We've just taken the word wanton. The word wanton exists, and there is a cost-benefit issue in, as we know right now in relation to Ukraine, this obligation not to target civilian targets. You've got to focus on military targets. This is the issue right now over these last few days. I've just come back from Ukraine, where bombs are raining down on manifestly civilian targets indiscriminately. That's manifestly illegal, cannot be done. But in other cases, there's a really difficult issue. I mean, that road bridge in Crimea, what is that? Is that a military target? Is it a civilian road? How do you characterize it? And the wantonness and the cost benefit and the balancing exercise is inherent already in international criminal law, and we wanted to make sure that it was easier to open the door to ecocide by basing it on what had come before. But undoubtedly there's a price paid for that.
Is this on? Yeah, I've got a quick follow-up question. I'm a pragmatist to Paul Redmond, King's College London. But I'm interested in the comparison in fracking in different contexts. So, for example, fracking could be ecocidal in Britain, but not in Ghana, even if it's the same quantum of fracking. So what the difference there is the human difference, the human context, and the historical context. So in that sense, it is anthropocentric, I can never pronounce that. But nonetheless, it's not wholly anthropocentric. So it's progress. So in that sense, I think I'm a pragmatist with you. But what's the equivalent on the side, if you like, of nature, quote unquote, to fracking? You know, it seems that the non-human is still passive. It is either fracked or not fracked. So what's the positive equivalent? Is it rewilding? Is it something else? So how can that be pushed forward beyond the sort of, you know, still incrementally practical, but still the non-human is in a passive recipient of either humans doing something to it or not?
I think this comes into the category of the second question that you asked, which I didn't answer because I'd forgotten, not because I didn't want to answer. But I've now reminded what the second part of your question was, which was that we had a limited mandate to come up with a definition, and that what will have to happen at the next stage, if it follows the process of the International Criminal Court as it has previously operated, is they will produce elements of crimes and they will identify precisely the responses to these types of questions. You could imagine a scenario. So it will come. I mean, if this is going to go to the ICC, there will have to be further elaboration, there will have to be further reflection. But you could imagine a scenario in relation to the cost-benefit type of thing where an individual says, yeah, but we provided compensatory mechanisms in relation to the protection of the same or some other environmental resources. And so on balance, the weighing exercise means that it's not wanton. And that would be extremely significant, actually, because one of the issues that we faced was what you deal with a scenario where the person just proceeds to do something without actually thinking through the consequences. For me, that act of omission, failure to take into regard the environmental consequences of your acts, can expose you, just as it can to crimes against humanity and genocide, to a legal and criminal liability. And it would be the same thing here. And what's interesting is that in that balancing exercise, if you integrate into the equation measures you've taken to repair, to restore, to rewild, or whatever it is, that's also going to help you show that actually it's not wanted because you took into account the ecological consequences and you commissioned reports and you got some people somewhere to go and tell you that yes, you were adding, 50 billion tons of carbon dioxide here, but you were reducing 53 billion tons of carbon dioxide there. Or we'll do fracking here in Guyana, but as a corporation, we'll compensate for the additional CO2 that is released in Guyana by reducing in the United Kingdom certain emissions by retrofitting, blah, 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 whatever. You can begin to see. The main thing about this idea for me is that it gets people to think about these things. It begins to move the environment to center stage instead of being a sort of tack on. That's what I care about, that change of consciousness that is inherent. I keep coming back to these wonderful documents. I mean, they really had extraordinary foresight. You're walking. I mean, it's just very moving for me to read those texts and imagine that these characters 250 years ago were thinking in exactly the same way about these issues.
Yeah. We must wrap in a moment. It's got one more question. The lady there was just waiting, so it's going to be the last one, and then we've got some drinks, I think. So.
Thank you so much for your talk. It's been really interesting. I wanted to ask a kind of broader scope question about the possibilities which introducing rights for nature could have outside of sort of protection, because I think the ecocide is very focused on persecuting and protecting the environment. But I was wondering if rights for nature could be used as a grounds to imply a moral duty for restoration, say the reintroduction of locally extinct species or the restoration of the environment based on animals' rights to habitat, for example, and whether this would be possible within this framework, or that would have to be done separately.
I hope that it would be. I hope that it would be catalytic. One of the nice things about the way the International Criminal Court works is that once a state has signed up to it or the definitions that it provides, they've got a legal obligation to change their domestic law to accord with the international standard, which means that it goes to the domestic parliament, and there's then a debate in most reasonable parliaments. Okay, how do we do this? What does this mean? What are the other things that we could be doing? And that, I think, is part of the attraction of going a top-down approach. I mean, you could criticize it. You could say that you ought to be doing bottom-up. It ought to be local communities deciding for themselves. And I'm generally very partial to that sort of E.F. Schumacher type of approach. Small is beautiful. I'm nervous. I'm not starry-eyed about international law, and I'm nervous about top-down kind of thinking and imposing on communities something they've had no role in contributing in, and so on and so forth. That raises fundamental problems. But I'm pretty convinced that if you leave it to local jurisdictions or regional jurisdictions or national jurisdictions, it's never going to happen in a systematic way. So you've got to probably have both. But my hope would be that it would be empowering of those ideas
at the local level, and at the regional level, and at the national level, and it would catalyse new ideas. You know, I'm a very big believer in the power of words and ideas. I really am an optimist. And the reason for that is what I came across on East West Street. I mean, the idea that these two characters in 1944, they've lost their entire families. Instead of lying down in a corner and weeping, which would have been a perfectly reasonable thing to have done, they used their knowledge, their ideas, and their energies, and came up with ideas that changed the world. And the ideas have not, of course, stopped horrible things from happening, but they were just ideas. I mean, they just, you know, it's very moving to go back to the origins of these two ideas, and you see them writing it out on pieces of paper. Read Hersch Lauterpacht's An International Bill of the Rights of Man, totally inspired by these texts that you've put up on the screen before, and just watch the way in which an idea of a single human being in a single place has a butterfly effect. And I think that's my hope for this concept of ecocide. And it has this effect, not of pitting one generation against another, but of enabling and empowering a younger generation to say, you've let us down, it's time that you guys got your act together, this is one way to do it, and here's 47 other ways to do it. And that's what is exciting about it for me.
And to end on a sort of similar optimistic note and focusing on the power of words, we should also remember the example that the publication of Rachel Carson's Silent Spring in the early 1960s was a direct line from that to Nixon establishing the Environmental Protection Agency. And rather wonderful in a way that people who we traditionally think of as maybe villains actually, you know, can do good things. Nixon, the Environmental Protection Agency, and as you say, Thatcher as the first leader to recognize climate change. So there is cause for optimism, and I think Philippe's work and the work of Jojo, whose Stop Ecocide Foundation led to it, has, you know, been extraordinary inspiration for all of us, as I hope you know, you have found this kind of historical background has been. So thank you all very much for coming along. Thank you to everybody who tuned in to the live stream. But for those of you actually physically here, I think there are some drinks in the foyer. But let's end just by thanking Philippe again for his